Good morning. We're about to go ahead and get started. First of all, thank you all for attending the local practice seminar. A couple housekeeping details. Please remember to fill out and turn in your yellow CLE certification before you leave today. You need to turn that in to receive your CLE credits. As a special treat today, our family wizard is here, and they are also hosting a lunch in the Studebaker room. If you would like to join them to learn more about this Parenting Time app and have a wrap, sandwich, or salad, stop by their booth and let them know you'll be coming. We appreciate Giuseppe for coming from Ohio today, so this is a great opportunity to learn more about this app and how it can help your clients. As a courtesy to the speakers and those around you, please silence your phones. United States Magistrate Judge Scott J. Frankel was sworn into office on August 13th, 2024. Bringing to the federal bench nearly 4 decades of distinguished service in the law. A proud graduate of the Ohio State University College of Law, Judge Frankel earned his degree with honors in 1985 and served as editor-in-chief of the Ohio State Law Journal, a role that hinted early on at his sharp intellect and leadership. After law school, he began his legal career clerking for United States District Judge David S. Porter in the Southern District of Ohio, an experience that laid the foundation for his lifelong commitment to justice. From there, he joined Mayer Brown, an international law firm based in Chicago, where he honed his litigation skills on complex civil matters. Drawn to the courtroom and the cause of defending the accused, Judge Frankel transitioned to the Cook County Public Defender's Office, handling a wide range of misdemeanor and felony cases. He later co-founded Frankel & Cohen, a firm that built a strong reputation for challenging civil rights and serious felony cases in both federal and state courts, at trial and on appeal. Before his appointment to the bench, Judge Frankel served as a staff attorney in the South Bend office of the Federal Community Defender, where he continued his dedication to ensuring fairness and due process for all. Now, as a United States Magistrate Judge, he brings that same depth of experience, compassion, and unwavering sense of justice to his work on the federal bench. It's my honor to introduce Magistrate Judge Scott J. Frankel. All right, Lisa. Sorry.
Thanks for that introduction, Lisa. That's, wow, humbling. So this presentation was billed as federal court update, but it was billed to me as let them know who you are. So the update is, I'm the new magistrate judge. The rest is about me, almost. So we're going to get going. I really want to thank the Bar Association for inviting me to speak to you today and introducing myself to the South Bend legal community. In this presentation, I'm going to discuss that's me, by the way, and I'm holding the Stanley Cup, the real Stanley Cup. Because when I lived in Chicago, the Chicago Blackhawks won the Stanley Cup 3 times, and I got invited to hold the Stanley Cup by a radio announcer whose wife was a partner of one of my good friends. And so everybody was standing in line. You got to hold the cup. You couldn't hold it over your head like they do on the ice, but you could hold it like that and get a picture taken. So that was one of the highlights of my life. Okay, so in this presentation, I'm going to discuss 3 areas: my personal background, professional background, and path to the bench, and a brief discussion of expectations for lawyers practicing in federal court. So this might be the easiest CLE you earn all day. I graduated from Oberlin College with a BA in economics and government, and I spent a semester in France during that time and traveled throughout Europe for a year, where I learned to love good food, coffee, wine, and eclairs, things that I still love. I went over there for a semester, and when the semester was over, I realized that the school had purchased us airline tickets that were open for 1 year. So when the program was over, I called my dad and said, "I'm not coming home." And he said, "What?" "Yeah, I'm not coming home." He said, "Well, how are you going to live?" And I really didn't know. But I somehow managed to survive for a year in Europe, traveling all around Europe. I made it to Israel, worked on a kibbutz, and then ended up in Paris for the flight home exactly a year later. So that was an amazing experience. Also, while in college, I worked some time in the student government, I was on the Student Finance Committee. I was chair of the Student Finance Committee, and that committee at Oberlin was responsible for hearing presentations from student groups, and we distributed money that student fees had been allotted to help the student culture grow at the Oberlin campus. So that was an interesting experience. But really, I focused on Frisbee, going to Grateful Dead shows, and I lived in a co-op where the residents were responsible for shared upkeep and cooking duties. So I laid the foundation for my love of cooking at that co-op. But mostly we were eating brown rice and tofu and broccoli. So I had a lot of growing to do in that regard. After Oberlin, I went to the Ohio State University Moritz College of Law, as it says up there. But when I attended, it was only known as Ohio State University College of Law. I graduated with honors. I managed to become editor-in-chief of the Ohio State Law Journal. While we were there, I helped organize a second law review that focused on mediation. And I believe that law review is still in operation. I'm very proud of that. And I also met my future partner, Lori, who attended law school for a year, and later left law school to follow me to Chicago, where she got a master's degree at University of Chicago. So there were many benefits in law school, including meeting my wife. My next move, I clerked for David Porter of the Southern District of Ohio in Cincinnati. So I spent most of my, early years in Ohio. I'm a true blue Buckeye and Ohio State fan. I hope that doesn't offend anybody here. And then after my clerkship, I worked at Mayer Brown and Platt, which is a big commercial law firm. And we were doing civil litigation on a big scale and a smaller scale. We had some massive lawsuits involving nuclear power plants that I was involved in. We also did smaller lawsuits involving personal injury cases that were referred to the firm, and they were always looking for the younger associates to take on more responsibility. And I always wanted to get into court because that was my idea of what lawyers do, is they get into court and they argue and they make presentations and win cases. And so I was always pushing to get into court. And so when I realized that I was pretty much going to be a junior attorney at Mayer Brown and Platt for the next 10 years, I had the idea of going to the Cook County Public Defender's Office. And when I did that, again, I had that phone call with my dad, and I said, I'm going from Mayer Brown to the Cook County Public Defender's Office. And his reaction was, what? He couldn't understand it, and maybe looking back, I wasn't sure what I was doing, but it was the right move for me, it turns out. But it set my career on a completely different trajectory, as you can imagine, and I became essentially a criminal defense attorney. I stayed in the public defender's office for about 4 years. I handled lots of drug cases and felony cases of all kinds, and serious felony cases as well, including murder cases. And my law partner, Mr. Cohn, Robert Cohn, he was at University of Chicago in their clinical program, and he wanted to start a firm as well. He did employment discrimination cases. So the two of us handled criminal and civil cases, lots of employment cases, civil rights cases. We did some consumer class action cases as well. Just a hodgepodge of civil cases on the civil side, and a lot of serious felony cases on the criminal side. And I ended up getting qualified to be lead counsel on the capital litigation bar, the Illinois Capital Litigation Bar. So I was appointed several state capital cases, which we litigated successfully, and also I was involved in federal capital cases, which involved a different type of litigation, and also trips to Washington, D.C. to pitch your case to the Justice Department. It was a very interesting challenge. So all of the experience of serious violent felonies and capital cases, it helped me become a better criminal defense attorney, of course, because I saw how in the capital litigation field, the lawyers really had to dig in into their clients' backgrounds. And approach our clients with a lot of empathy and respect, which is a skill that, as a lawyer, maybe you don't automatically come to. But the clients we had, of course, charged with the most serious offenses are challenging clients, difficult, and they push back a lot, and they're not happy with the things that you're telling them. And one of the skills you have to develop in that area is coming back again and again to that client, making sure they understand that you're not going to abandon them like they've been abandoned by so many people in authority throughout their lives. And eventually they open up to you, and it's those moments where they open up to you that you can glean important facts about their lives that will help you save their life later. So it was a very powerful experience litigating these capital cases, and the things that I learned in that area I took with me when I came here to the Federal Defender's Office. So along the way, yes, I tried this murder case, and my friend Tom Gagan, who's written several books, and he's actually been reviewed in the New York Times, and he writes columns all over the place. He's an interesting guy. I really love him. And he was always complaining about how, as a civil lawyer, he never got to try a jury trial. So I invited him to try this jury trial. I said, it's going to be easy. It was a remand, and we had the transcript from the first trial. All you have to do is read the transcript. You'll know exactly what we need to do the second time, except this time we're going to win it. And so he joined me in this case, and we did win it. But I didn't know he was going to write a book about it. If I had known that he was going to write a book about it, I'm not sure I would have brought him in on it, because I really wasn't sure we were going to win it. But the book has a good ending, because we did win that case. We got the not guilty. And it's an interesting read. I don't know if it's in print, but I have one copy in my chamber, so if you really want to read it, you can borrow it from me. Okay, and then in 2018, I arrived in South Bend and was employed as a staff attorney at the Federal Community Defender's Office. And I made that transition from Chicago after my kids graduated high school, and I was ready for a paycheck. Because in private practice, the stress of running a business and the ups and downs of the financial end of it just wore me down after a while. And I was like, well, I'm ready for the next challenge, and this position opened up, so I came over here. And Jerry Flynn, who runs the office, is a fantastic guy and was a fantastic boss. I came over here, and it was a great experience. There are two lawyers. Most of you probably know David Vanderkoy, who was the other lawyer in the office. He was a professor, a clinical professor at Valparaiso. And he was also a friend of mine. We had done cases together. We had done a capital case together. We were working on a murder case together, more on that some other time. So when I found out that he was going to be the other lawyer who was working in the office, I was very pleased. I was really happy to know that this old legal friend was going to be in the office as well, and it really worked out well for us. So I was there, I started in 2018, and I was appointed to the bench last year. The position opened up after Magistrate Judge Gotch retired, and I just thought I'd throw my hat in the ring. I had all this experience, civil, criminal, the most serious criminal litigation experience you can imagine, also class action cases, everything that you would need to become a magistrate judge. And much to my surprise, I got the job. And I'm still thankful. I pinch myself every day. I really never expected that outcome, but here we are, and I'm really pleased that it happened. As I was just explaining to someone, this is a job that comes at the latter time in my career, but it comes in a way that challenges me to learn brand new things. Something that, being a lawyer, all of us can appreciate. It's a career and a profession that allows us to continually challenge ourselves and grow ourselves emotionally and intellectually, find out new things about the world, and try to become a better person. It's kind of a lofty goal, but I really think that the legal profession offers that to us if we take the challenges seriously and we challenge ourselves every day along the way, which is what I've tried to do. Okay, now we're in the personal life a little bit. This is my wife, Lori, and we've been married 39 years on Saturday, so I remembered that, and kudos to me. She's the executive director of Musical Arts Indiana, a nonprofit organization, and that consists of a very accomplished choral group of adults as well as a youth chorus. We like to, as the pictures show, we have a dog, Harvey. He's a therapy dog. He's in training right there. He won the blue ribbon. And Lori takes him to hospitals and hospice centers, and he provides comfort to people. And it's our first golden retriever. If you've ever had one, you know what I'm talking about, but these are extraordinary dogs. He is so sweet and connected and emotionally drawn to human beings that he's really been a special part of our lives there. And we like to go to concerts. Bob Dylan was in South Bend. That was incredible. And travel, that's a picture of us in Iceland, a trip I would recommend. And if you have any questions about Iceland, see me later. Last year we went to Mexico City. My daughter's at a cafe in Mexico City. That's another place I would highly recommend. It's a wonderful city, so bustling and noisy and vibrant. There's music everywhere and food everywhere. It was really a surprise what we encountered there. And I have two kids. My son, Owen, as you can see, is a musician. He plays jazz and rock music. He's in Chicago now, and he's actually, I don't know, he's making some money. He has a day job as a teacher's aide at a private Jewish day school. And then at night, he's gigging all the time with different musicians, and he has a music studio that he goes to in his spare time. So as a dad, I'm happy about that. He's not on the computer or working on his device. He's actually working on that bass, and that's the highest priority for him. And my daughter, she's there on a boat on Lake Superior, and she is, and that's my wife again, and Millie on Lake Superior. She's getting a master's degree in creative writing at University of Northern Michigan, and she's in her second year. So she's a teacher there and also working on her master's degree. Okay, a little bit about my spare time. This somewhat covers it. I'm obsessed about coffee. So in the lower left-hand corner, you can see that we always have 3 or 4 different kinds of beans in the house and different ways of making coffee. No drip coffee, but just the pour over is what we do every morning. Even the ground coffee, if it's done right, or the freeze-dried coffee can be good under certain circumstances. There's a New York Times recipe for it if you want to look that up. I have a garden. We grow tomatoes. There's some cherry tomatoes. Those are the easiest things, and some peppers. But I'm not the best gardener, so I'm a much better lawyer than I am a gardener, so no retirement soon to garden. I played hockey for a long time in Chicago in an adult beginner hockey league. I never really graduated past beginner hockey, but I did love hockey. I still love it. I love to watch it. I think it's the greatest game possible, and that's how I got the connection to the Stanley Cup. We used to have tickets to the Blackhawks games, too, way up in the nosebleed sections. So we were able to attend some of those Blackhawks playoffs, and let me tell you, that was really wonderful. There's a lot. I live in Southwest Michigan, and there's a lot of fruit there, so I do make jam from time to time with moderate success. So that's a picture of some grape jam, I think. And then, of course, pastries and bakeries, because I love those and I eat too much. So that goes without saying. Okay, so that's enough about me, really. Now let's talk about what magistrates do. I find that a lot of the lawyers who practice mostly in state court, which is most lawyers, don't really know the role of the magistrate judge in federal court. So on the criminal side, we handle initial appearances where we give the defendant their rights. So it's mostly the judge doing all the talking and explaining that an individual has a right to silence, a right to an attorney, and some other rights that they have. And then we handle the issue of appointment of a lawyer at the initial appearance. If the person is charged with a complaint, we have to do a preliminary hearing if they ask for one. And if they're charged with an indictment, then we conduct the arraignment. That's when they plead not guilty. And then after those initial proceedings happen, we go forward into the detention hearing. I'm gathering that the rules that we're required to follow in federal court are different from state court, because a lot of times the client's lawyers will tell us that the client was on bond in state court. How come he's now back in custody in federal court for essentially the same charge if the case has been federalized by the U.S. Attorney's Office? The fact is, it's just harder to get out in federal court. The rules and the balancing are pretty strict, and most people have to fight their cases from in custody. But I do try to keep a sympathetic ear and a compassionate attitude towards the defendants and release people when they deserve it. It's a tough call. As I was explaining recently to someone, there's some easy ones where you're never going to release the guy, or you're always going to release the guy. And then there's the difficult ones in the middle, and that's where the judge comes in, and you have to make the call, and that's what you took the job to do, is make that tough call. In civil matters, we handle all non-dispositive motions in cases where the parties have not consented to our jurisdiction. So you know what a dispositive motion is. It's motion to dismiss, motion for summary judgment, things that will dispose of the entire case. Those have to be handled by an Article III judge. So they would go to Judge Lichty or Judge Briscoe in South Bend. Now, the parties can consent to our jurisdiction if they decide that they want to. The advantages of that, I would say, are some swifter, hopefully, resolution of the case, maybe some more hands-on attention, focus on the case a little bit, because we don't have as many full consents as, say, the Judge Lichty or Judge Briscoe would have. So we might be able to help you there. But mostly our job is to do all the pretrial matters regarding discovery deadlines and keep a focus on the case to make sure the case continues to move forward towards resolution. And we also do settlement conferences in cases that either are not consented to us or we're not handling the pretrial matters or something like that. And so we can handle the mediations. So if your party is looking for a mediator, I know the federal rules require you to designate a mediator, a paid mediator, rather than have the judge handle it. But we're available to handle mediations and settlement conferences as well. Okay, expectations of the court. So what we're hoping, I'm going to start with criminal matters. What we're hoping is that once a lawyer is appointed or retained in a criminal matter, they make an effort to visit the client in the jail, if that's where they're located, before the first court date, the initial appearance, to discuss the charges and the possible penalties. Because we're going to go through the charges and the possible penalties at the initial appearance, and if the client has already heard it once, it's going to sink in better for them, and we don't have to do it with so much detail. If the client hasn't had any encounter with the complaint or the indictment, I'm going to read it to them to make sure they understand what's going on and try to answer any questions that they have. When I first started at the Federal Defender's Office, it wasn't the practice for the court to have lawyers present at the initial appearance. And it made me very nervous because coming from Chicago, I was used to getting involved at the initial appearance with the new clients. And I was sitting in court in Judge Gotch's courtroom, and I would see defendants talking to the judge without a lawyer sitting next to them. I was like, well, how can this possibly happen? This is very dangerous for that person. They can make admissions. The consequences in federal court are pretty high. The penalties are pretty high, so you always want to be protective of the client's situation at that moment. But eventually, I think Jerry, who runs the office, as I said, he was under pressure from other federal defender programs, and he was going to seminars and learning that attorneys are regularly present at the initial appearance, and so that's the way we ended up going. Attorneys are almost always present at initial appearances. Sometimes a special consideration can be made because we're a small jurisdiction. There are a ton of lawyers available all the time. There's problems with scheduling, and once in a blue moon, we'll have an initial appearance without an attorney present. But that's a situation that I'm trying to avoid as much as possible. As far as the detention hearing goes, if anybody in here is going to handle a detention hearing, what I like to see, what we want to hear is that the client, though I have the criminal history of the client, that's clear to me, but will the client have a place to live that's stable? Do they have family ties that are going to watch out and make sure they comply with all the court's rules? Have they been working? Do they have strong emotional ties with someone, if it's not their family, someone else that will ensure that they appear for court and that they have an incentive not to be a danger to the community once they're released? So I think sometimes the lawyers have a tendency to fold at the detention hearing if they look at the client's record and see that they probably don't have a shot at getting out, in their opinion. Never fold. That's what I would encourage you to do. Always put on the strongest presentation that you can. I want to be challenged. I want it to be a very difficult decision for me. The harder the decision, the better. And so if you can make a strong case that your client should get out, even if they have a terrible record or the particular offense is somewhat jarring and difficult, always make a strong argument for bond, because you never know, and I never know. In civil matters, there's a high expectation that the attorneys will be aware of the rules of federal civil procedure and the applicable local rules. So one of the things that we see attorneys not get correctly initially is the corporate disclosure statement, and it's so simple, really. And I brought a copy of it. I wish I had put it in our PowerPoint, but there's a local general order that explains what is required in the corporate disclosure statement. It's just A, B, and C. I'm not going to read it, but if you follow A, B, and C, you're going to get it right every time. So I think we're seeing a lot of lawyers who aren't from the South Bend area, maybe, or from other states, not read the local rules, but it's a simple formula. That's the easiest one to get right. As far as orders of protection go, sometimes we kick them back because the incorrect language is used. If too much is protected, the policy in federal court is that as much as possible should be public and disclosed. So protective orders, while we understand the important role of protective orders in commercial litigation, for example, in moving the case forward, we want to keep them as narrow as possible. And there's case law about what language you can use in these protective orders, and you can't use general language to say all trade secrets, for example, are going to be protected. You have to be more specific than that. And the descriptions have to be related to the litigation that you're involved in and whatever. So if it's a specific patent on a machine, you've got to talk about what you're trying to keep from public disclosure, which we understand there's an interest in doing that. But again, I would refer you to our website. I have a website which also has templates on it, and the templates would make it easier for you if you just follow them. There's a report of parties planning meeting, preliminary pretrial conference, protective order template, ESI protocol template, and others. And all these things, it's just all you have to do is fill in the blanks in a way. I mean, you don't have to use the template exactly, but it'll help you get through the screening process that we have to make sure that the initial litigation is getting off to on the right foot. Okay, so If you get frustrated by us because we're kicking back your protective order too many times, bear with us. We're just trying to get it right, and we're trying to follow the law and do the right thing. We're trying to protect the public and also make sure that your litigation can go forward in the way you hope it can, and that the parties, my goal as a magistrate judge is to get the parties to a mutual resolution, one that's acceptable to everyone without having to go through summary judgment or a trial. Yes, I could say with pretty good confidence that our templates will work for both Judge Briscoe and Judge Lichty. I am the magistrate judge for some of the other judges, of course, in the Northern District. I think it would work across the board for all of them, but I don't have 100% confidence that they wouldn't kick it back. So I haven't encountered that situation. Okay, so if you haven't been to federal court, here I am. You know, we're trying to be user-friendly. We follow the law as much as we can. We're trying to make the right decisions. We're also cognizant that the cases are really about the lawyers, and it's about the lawyers talking to each other as much as possible and understanding the worth of their case and reaching a mutual resolution. So that's what we're trying to do. In conclusion, oh, that's my son. That's him. I forgot about that. He's working on it. I'm blushing. Very proud of him. So he gets up on stage, and he always has since he was just little, and always amazed us. So, okay, in conclusion, I would say that I'm going to end the way I started, that being a magistrate judge is a dream, really. It's a wonderful position. I'm so glad I was chosen and grateful every day that I have this opportunity to do this job. The best part is, as I said before, learning every day, growing every day. That's really what I think life is all about, if you can be lucky enough to access that. And I really appreciate all of you for listening to me and coming to this presentation. So thank you very much.
The magistrate said if anybody has any questions, clearly not about pending cases, but anything he can answer, he's happy to take questions.
Yeah, I know it's the chief judge put out a general order changing the way cases are assigned, basically to try to encourage more magistrate consent.
Right.
I just wondered how that's going. Are you getting more consent in civil cases?
I'm getting just a slight uptick. The idea, for those of you who don't know, is that the magistrate judges were placed on the assignment wheel along with the district court judges. So you may file a case and see that I've been assigned as the judge without any district court judge also assigned. So I'm not just the referred magistrate judge, but potentially the judge who handles the case. And then we'll do all the screening and the preliminary matters, and as soon as if a motion to dismiss is filed, for example, we're going to have to send it up to one of the other judges. But at some point, the parties will get consent forms to decide whether to consent to us. If you don't consent, the case gets thrown back into the wheel. You might get another magistrate at that point. That's how it's working. Has it worked? I am getting a consistent number of consents. I don't know if I've seen a huge uptick yet. Maybe that's going to happen. I think it's a good faith effort to try to increase consents, and it takes some of the load off the district court judges and spreads the burden around and the time commitment around a little bit better.
And is there a rule of thumb
I don't think so, to be honest with you. I mean, we hope to be faster. Sometimes the litigation gets bogged down in the attorneys themselves, and we try to unstick the litigation as much as we can. If we had dispositive motions like summary judgment motions and things like that, we would clearly try to get them get to them as fast as possible. I don't really know. I don't know the statistics on how long it takes Judge Briscoe or Judge Lichty to get to a motion for summary judgment. We can get to trial faster in front of me for sure. And we have a lot of pro se filings in the Northern District from prisoners, because the Northern District has, I think, all the Indiana prisons practically. So a lot of those are getting ready to go to trial, and those get to go to trial a lot faster if they're in front of the magistrate. Okay. We're good. Thank you.